Hey there, my next home family. I wanted to update you on some breaking news. We've been talking about these lawsuits for quite some time, and I have told you all about the agreements to settle that we've heard about, with Anywhere committing to pay $83.5 million and Remax committing to pay $55 million, both also agreeing to change their business practices. What we did not know until today was the terms of those settlement agreements. I will preface this by saying that this is information that's released that we understand is agreed upon, but the rules of the settlement must still be confirmed by the court, and the hearing for preliminary approval is in November, and a possible final court approval for settlement not until mid-2024. So I want to tell you about those terms of the settlement because ultimately they both are very similar, which is interesting, and honestly the expectation of what we can expect moving forward. As a briefing, Remax and Anywhere. Anywhere is Better Homes and Gardens, Century 21, Coldwell Banker, Cochrane ERA, and Sotheby's, all under that Anywhere brand, have both agreed to settle the lawsuits along with NAR and Keller Williams in this specific lawsuit that is supposed to go to trial next week, October 16th. Keller Williams and NAR have made no agreement to settle as of today. So, as I mentioned, there's large money at stake, both agreeing to change business practices. Specifically, what that means is that both companies said they will no longer require their associates to belong to NAR or follow its code of ethics or any MLS handbook. Interesting. I've told you that it's important for us to not leave NAR right now. And the reason why is if NAR does decide to settle, any member of NAR will be protected under that settlement agreement. They should be protected for past, current, and future lawsuits. So that's why we are not leaving NAR right now. Remax and Anywhere can choose to leave NAR because they have individually settled. Okay. They have both said that they will prohibit their agents from using any technology to sort listings by compensation. There will be no minimum requirements by the firm for compensation. Some firms have I'm going to require you to have 1% or 2% or a certain dollar amount, and neither will have any minimums. They will also disclose that commissions are not set by law, and there are no minimum client commission requirements. So we are supposed to tell our buyers and our sellers, certainly our sellers the most, that there's no rule requiring offers of compensation. So those are both groups, similar language in these settlements. Remax has added that they recommend adding disclosures for sellers that notes that commissions are negotiable. I think this is really important moving forward, probably for all of us. And we're going to have our attorney draft something ASAP that our sellers sign that say, we understand very clearly what our choices are and we choose X. Sign on the dotted line. So that's how we are going to move forward. And then Remax also said that we will continue to display offers of cooperative compensation where such data is available. So as of right now, that has not been a rule that has changed or eliminated from MLSs. NAR, of course, did just say today that they would allow zero compensation in the MLS. So clearly there's some working going on behind the scenes, but the rhetoric from the attorneys on the plaintiff side note that looks like a negative for them. It looks like they are agreeing that they are in the wrong. So this all being said, we still don't have any answers. What I want you to remember is that the sky is not falling, that our job is to pivot and change, in any industry, pivot and change. We're good at that. What we need to focus on is being able to express our value as buyer's agents and understand that we may have to get our buyer to pay us. And there are a myriad of ways that we can do that. from concessions to referral agreements to financing. There's lots of different options. We don't have all the answers yet, but the one thing that you can walk away with and work on right now is having a very strong buyer consultation, because buyer agency agreements, in my opinion, will be required in every state, in addition to listing agreements that do disclose what the seller's options are. So if the seller is not offering compensation, we need to be very careful with our sellers and tell them that that's okay. We're not allowed to tell them that because they're offering zero compensation, nobody will come see their house. That's part of this problem. As a buyer agent, we cannot say, well, this person's offering 3 apples and this person's offering 1 apple, and we shouldn't go see the 1 apple. We'll have to explain our value, and we'll have to express some different ways that we would be able to achieve what we are charging them. Remember that we are going to charge our buyers like we do in the North Carolina Buyer Agency Agreement already. We have an agreement with our buyers, just like we do when we go to a listing presentation. When you go in a listing presentation, you do not walk out of that room without having a listing agreement signed. You know exactly what you're going to get paid. They know exactly what you're going to do and exactly how much they're going to pay you. And moving forward, your buyer consultation should be exactly the same conversation. All right, that's where we are today. I still find that there are a lot of real estate agents that do not know anything about these lawsuits. And if they do, they have a lot of misinformation. So please feel free. You have my permission to share this video with anyone that you want. This isn't recruiting. This is a we are in this together, industry-wide sharing of information. Feel free to call me if you have any questions. Jamie Downey, Next Home in Charlotte, North Carolina.